May 4, 2023. Unit 10. Real Property Security Devices, Annual Percentage Yield, APY. Anti-merger clause. Assignment of rent. Bait and switch advertising. Balloon payment. Beneficiary statement. Blanket encumbrance. California Homeowners Bill of Rights. California Housing Financial Discrimination Act of 1977. Certificate of Sale. Controlled Business Arrangement. Covered Loan Act. Defeasance Clause. Deficiency Judgment, Dodd-Frank Act. Dragnet Clause. Due on Sale Clause, Equal Credit Opportunity Act, Fair Credit Reporting Act. Fictitious Trust Deed. Financing Statement, GARN Act. Holder in due course, hypothecate, loan estimate. Lock-in Clause, Mortgage Forgiveness Debt Relief Act. Negotiable Instruments. Notice of Delinquency. Obligatory Advances. Or More Clause. Partially amortized note. Predatory lending. Promissory note. Real Estate Settlement Procedures Act. Real Property Sales Contract. Rent scamming. Request for notice of default. Right of redemption. Security agreement. Service Members Civil Relief Act. Subject to. Trust Deed. Truth in Lending Act. Truth in Savings Act. Wraparound Loan. 1. Annual Percentage Yield, APY. The total amount of interest earned on an investment or savings account in a year, expressed as a percentage of the initial investment. 2. Anti-merger clause, a legal provision in a contract that prohibits one or both parties from merging or consolidating with another company or entity, usually for a specified period of time. 3. Assignment of rent, the transfer of the right to collect rental income from a property from one party to another, usually as collateral for a loan or as part of a sale agreement. 4. Bait and switch advertising, a marketing tactic that involves luring customers in with an attractive offer, only to then push them towards a more expensive or less desirable product or service. 5. Balloon payment, a large, one-time payment due at the end of a loan term, typically used in loans with lower monthly payments but a higher overall cost. 6. Beneficiary statement, a document that outlines the remaining balance and terms of a loan or mortgage, typically provided by the lender to the borrower or the borrower's estate in the event of their death or disability. 7. Blanket encumbrance, a legal claim or lien against multiple properties or assets, rather than just one specific property. This type of encumbrance is often used in commercial real estate loans where multiple properties are used as collateral. 8. California Homeowners Bill of Rights, a set of laws enacted in California in 2013 to protect homeowners from unfair or deceptive practices by lenders and loan servicers, particularly during the foreclosure process. 9. California Housing Financial Discrimination Act of 1977, a California state law that prohibits discrimination in housing based on race, color, religion, national origin, ancestry, sex, disability, or familial status. 10. Certificate of Sale, a document issued by a court or government agency confirming the sale of a property at a public auction, typically used in cases of foreclosure or tax sales. 11. Controlled Business Arrangement, a business relationship between a real estate broker and a settlement service provider, such as a title company or mortgage lender, in which the broker has an ownership interest in the provider. These arrangements are regulated by the Real Estate Settlement Procedures Act, RESPA, to prevent conflicts of interest and ensure fair competition. 12. Covered Loan Act, a California state law that requires lenders to provide additional disclosures and protections for certain high-cost loans, such as those with high interest rates or fees. This law is intended to protect consumers from predatory lending practices. 1. Defeasance Clause, a provision in a mortgage or loan agreement that allows the borrower to regain control of the property or asset used as collateral once the debt has been fully paid or discharged. This clause typically requires the borrower to fulfill certain conditions or obligations in order to trigger the release of the collateral. 2. Deficiency Judgment, a court order that requires a borrower to pay the difference between the outstanding balance on a loan and the amount received from the sale of the collateral used to secure the loan. This typically occurs when the sale of the collateral does not fully satisfy the debt owed. 3. Dodd-Frank Act, a federal law passed in 2010 in response to the 2008 financial crisis. The law established a variety of new regulations and oversight mechanisms for the financial industry, including provisions related to mortgage lending and consumer protection. 4. Dragnet clause, a legal provision that allows a lender to secure a loan with any and all collateral owned by the borrower, regardless of whether or not the collateral was specifically identified in the loan agreement. This clause is often used in commercial loans and can provide greater flexibility and security for the lender. 5. Due on sale clause, a provision in a mortgage or loan agreement that requires the borrower to pay the full outstanding balance of the loan if the property or asset used as collateral is sold or transferred to a new owner. This clause is designed to protect the lender's interest in the collateral and prevent the loan from being assumed by someone else without the lender's consent. 6. Equal Credit Opportunity Act, a federal law that prohibits discrimination in lending on the basis of race, color, religion, national origin, sex, marital status, age, or receipt of public assistance. The law requires lenders to provide equal access to credit and to evaluate loan applications based on objective criteria rather than personal characteristics. 1. Fair Credit Reporting Act, a federal law that regulates the collection, use, and dissemination of consumer credit information by credit reporting agencies. The law requires that credit reports be accurate and fair, and gives consumers the right to access and correct their credit reports. 2. Fictitious Trust Deed, a fraudulent document that purports to transfer ownership of a property from the true owner to a third party, usually for the purpose of obtaining a loan or other financial benefit. Fictitious trust deeds are illegal and can result in criminal charges for those involved. 3. Financing Statement, a legal document filed by a lender to establish a security interest in personal property used as collateral for a loan. The financing statement provides notice to other potential creditors of the lender's claim to the collateral and is typically filed with the state or local government. 4. Garn Act, a federal law that limits the amount of wages that can be garnished by creditors to satisfy a debt. The law provides certain exemptions for low-income earners and sets a maximum percentage of wages that can be garnished, depending on the type of debt. 5. Holder in due course, a legal term that refers to someone who has acquired a negotiable instrument, such as a promissory note or check, in good faith and for value, without notice of any defects or problems with the instrument. A holder in due course is entitled to enforce the instrument against the original issuer, even if there are disputes or problems with the underlying transaction. 6. Hypothecate, to pledge property or assets as collateral for a loan without transferring ownership of the property. Hypothecation is common in real estate and other types of secured lending, and allows borrowers to retain ownership of their property while still obtaining financing. 1. Loan Estimate, a document provided to a borrower by a lender that details the terms and estimated costs of a mortgage loan. The loan estimate is designed to help borrowers understand the true costs of a loan and to compare offers from different lenders. 2. Lock-in clause, a provision in a mortgage agreement that guarantees a specific interest rate and other terms for a certain period of time. The lock-in period is usually a few weeks to a few months, and protects the borrower from fluctuations in interest rates while the loan is being processed. 3. Mortgage, a legal agreement in which a lender provides financing to a borrower to purchase real estate or other property. The mortgage gives the lender a security interest in the property, and allows the lender to foreclose on the property if the borrower fails to repay the loan. 4. Mortgage Forgiveness Debt Relief Act, a federal law that provides tax relief to homeowners who have had their mortgage debt forgiven or canceled by a lender. The law applies to certain types of mortgage debt, such as that forgiven in a short sale or foreclosure. 5. Negotiable Instruments, a legal term that refers to written promises to pay a certain amount of money, such as checks, promissory notes, and bills of exchange. Negotiable instruments are transferable and can be bought and sold like other types of property. 6. Notice of Delinquency, a written notice sent to a borrower by a lender or servicer indicating that a mortgage or other loan is past due and that the borrower may be subject to foreclosure or other collection actions. 1. Obligatory Advances, a provision in a mortgage agreement that requires the lender to advance funds for certain specified purposes, such as construction or repairs. The borrower typically must provide documentation of the expenses and the lender may make payments directly to the contractors or suppliers. 2. Or more clause, a provision in a mortgage agreement that allows the lender to increase the interest rate or other charges under certain circumstances, such as if the borrower defaults on the loan or if there are changes in the economic conditions. 3. Partially amortized note, a type of loan that requires the borrower to make regular payments of principal and interest, but the payments are not sufficient to fully pay off the loan by the end of the term. At the end of the loan term, the borrower must make a balloon payment to pay off the remaining balance. 1. Predatory lending, a term used to describe unethical or abusive lending practices that take advantage of vulnerable borrowers, such as those with poor credit or limited financial resources. Predatory lending practices may include charging high fees or interest rates, making loans with unfavorable terms or hidden costs, and engaging in deceptive or fraudulent practices. 2. Promissory note, a written promise to pay a certain amount of money to a lender or other creditor. Promissory notes are often used in real estate transactions to document loans or other types of financing. 3. Real Estate Settlement Procedures Act, a federal law that requires lenders and other parties involved in real estate transactions to provide borrowers with certain disclosures and to follow specific procedures during the loan origination and settlement process. The law is intended to protect consumers from unfair or deceptive practices and to promote transparency and fairness in real estate transactions. 4. Real Property Sales Contract, a legal agreement between a buyer and a seller of real estate that sets forth the terms and conditions of the sale. The contract typically includes information about the purchase price, the property description, any contingencies or conditions of the sale, and the rights and obligations of the parties. 5. Rent skimming, a term used to describe the practice of collecting rent payments from tenants without using the funds to pay the mortgage or other expenses associated with the property. Rent skimming is illegal and can result in civil and criminal penalties. 6. Request for notice of default, a written request from a party with an interest in the property, such as a lender or a lien holder, asking to be notified if the property owner defaults on their mortgage or other obligations. The request is typically filed with the county recorder's office and can help protect the interests of the requesting party in the event of a foreclosure. 1. Right of redemption, a legal right that allows a borrower to reclaim their property after a foreclosure or other default by paying off the outstanding debt and associated costs. The right of redemption may be limited or prohibited by state law. 2. Security agreement, a legal agreement that creates a security interest in property, such as real estate or personal property, to secure a debt or obligation. The agreement typically provides the lender with the right to take possession of the property or sell it to satisfy the debt in the event of a default. 3. Service Members Civil Relief Act, a federal law that provides certain protections to members of the military and their families, including provisions related to default judgments, evictions, and foreclosures. The law is intended to help ensure that service members are not disadvantaged or unfairly penalized due to their military service. 4. Subject to, a term used to describe a real estate transaction in which the buyer agrees to take over the existing mortgage or other liens on the property, but is not personally liable for the debt. The seller remains responsible for the debt, but the buyer may risk losing the property if the seller defaults. 5. Trust deed, a legal document used in some states to secure a mortgage or other debt on real estate. The trust deed transfers legal title to a trustee, who holds the property as security for the debt. If the borrower defaults, the trustee may sell the property to satisfy the debt. 6. Truth in Lending Act, a federal law that requires lenders and other creditors to provide borrowers with certain disclosures related to the terms and costs of credit. The law is intended to help consumers make informed decisions about borrowing and to prevent unfair or deceptive lending practices. 1. Truth in Savings Act, a federal law that requires financial institutions to provide consumers with clear and accurate information about the interest rates, fees, and other terms and conditions of deposit accounts, such as savings accounts and certificates of deposit. The law is intended to promote transparency and competition in the banking industry and to help consumers make informed decisions about their finances. 2. Wraparound loan, a type of financing in which a new loan is created to cover the balance of an existing loan, with the new loan being secured by a second mortgage or deed of trust. The borrower makes payments on the new loan, which includes the balance of the existing loan and any additional funds needed. Wraparound loans may be used to finance the purchase of real estate or to refinance existing debt. A promissory note is the evidence of the debt. It is an unconditional written promise signed by the maker to pay a certain sum in money now or at a specific time in the future. Straight note. A straight note is an interest-only payment note with the principal to be paid in full when due. The advantage to the borrower is a lower payment than what would be required with an amortized note. Installment note. An installment note provides for regular payments of principal and interest. Amortized note. The regular payments for a fully amortized installment loan pay off the entire principal, as well as the interest during the loan term. A partially amortized note would have payments based on an amortization schedule, but it would have to be paid in full at a date before the end of the amortization schedule. Balloon payment. While not money, negotiable instruments are freely transferable and are used in lieu of money. They are either promises to pay, notes, or orders to another to pay, drafts. Balloon payments. Often, installment notes provide that the entire balance will be due at a date before the notes being fully amortized. Such notes are called partially amortized notes, and the large payment is known as a balloon payment. A balloon payment is described as a payment more than twice the amount of the smallest payment. Due on sale clause, also known as an alienation clause. The due on sale clause calls for the note to be paid in full upon sale of the property. It accelerates the payments. Loans with due on sale clauses cannot be assumed. Congress then passed the GARN Act, Garnistry Germain Depository Institution Act. The act allowed lenders to enforce due on sale clauses unless the loan was made or assumed under state law that allowed loan assumptions at that time. Due on encumbrance clause. The due on encumbrance clause accelerates the payments on a loan if the owner places a further encumbrance on the property. Acceleration upon default. Even when a note states that all payments on the note become due upon default, a borrower can cure a debt that becomes accelerated because of default of payment on principal, interest, taxes, or insurance by paying the amount in arrears plus costs up to 5 days before sale under a trust deed power of sale foreclosure, or at any time before entry of a decree or on a mortgage foreclosure by court action. Prepayment penalties. The justification for prepayment penalties is that prepayment means an interest loss for the lender until the money has been placed in a new loan, as well as the expense of placing a new loan. Prepayment penalties are not allowed on FHA insured or VA guaranteed loans. Usury interest rate. Usury is charging a rate of interest greater than allowed by law. Impound accounts. Impound accounts are trust account reserves kept by the lender for advance payments made by the borrower for property taxes and insurance. The impound account protects the lender in that funds will be available for the taxes and insurance when they are due. Mortgages and trust deeds. While a promissory note is the evidence of the debt, a security device, such as a mortgage or a trust deed, provides security for the note. Mortgages and trust deeds hypothecate, or pledge, the property. The borrower keeps possession but gives a security interest. Mortgages. A mortgage is a two-party security instrument in which the mortgager is the owner or the buyer who gives a lien to the mortgagee. The mortgagee is the lender in cases of a hard money loan, where money actually is advanced, or the seller in cases of a purchase money loan, where the seller finances the buyer. Mortgages are a common real estate financing instrument in many states. California, however, favors trust deeds, and mortgages are seldom encountered. When a mortgage is recorded, it becomes a lien on the property. When the note is paid, the mortgagee gives the mortgager a satisfaction of mortgage. The satisfaction, when recorded, removes the lien. The defeasance clause in the mortgage provides for the cancellation of the lien upon full payment. Right of redemption. California statutes allow a mortgagor to recover the property after a judicial foreclosure sale. This is called the right of redemption. If the sale proceeds or less than the foreclosing mortgage debt, the mortgagor has a 1-year period of redemption. If the sale proceeds satisfied the foreclosing mortgagee's debt, the period of redemption is 3 months. By paying the purchaser at foreclosure the sale cost plus interest within the redemption period, the mortgagor can regain title. After the sale, the sheriff provides the high bidder a certificate of sale stating that the property is subject to redemption rights. This certificate of sale is recorded. Within 1 week of the sale, the sheriff must inform the debtor of the right to redeem. If the property is not redeemed during the redemption period, the sheriff issues a sheriff's deed. Deficiency judgments. Should the judicial foreclosure sale bring less than the amount owed on the mortgage, the foreclosing lien holder can apply for a deficiency judgment for the difference, but must do so within 3 months of the sale. Deed in lieu of foreclosure. Often a mortgagee, instead of foreclosing, will have the mortgagor deed the property to the mortgagee. The mortgagee benefits by saving time and foreclosure costs, as well as by avoiding the mortgagor's rights of redemption. The mortgagor benefits by avoiding having the credit reports show a foreclosure. Deeds in lieu of foreclosure often are given in exchange for cash or several months free rent. An anti-merger clause in a mortgage provides that the senior lien holder will retain priority over junior liens in the event of merger. Mortgage Forgiveness Debt Relief Act of 2007. Forgiveness of a debt is considered a taxable gain to the debtor. Trust deeds. Because of the lengthy and costly foreclosure associated with mortgages, as well as the redemption rights that can accrue after the foreclosure sale, the trust deed is the most common real estate financing instrument in California. While a mortgage is a two-party instrument, a trust deed is a three-party transaction. Naked legal title is transferred by the buyer or borrower, the trustor, to a third person, a trustee, as security for a note that is given to the lender or seller, the beneficiary. When the trustor finishes paying off the note, the beneficiary delivers the note and trust deed to the trustee with a request for full reconveyance. Failure to provide the deed of reconveyance within 21 to 30 days of demand can subject the trustee to damages plus a $500 penalty, the same penalty as for failure to provide satisfaction of a mortgage. Trust deed foreclosure. In the event the trustor defaults on trust deed obligations, foreclosure is made by private sale and is relatively quick and inexpensive, because the trustee and not the trustor has the legal title. Default can occur for a number of reasons, such as failure to make loan payments, pay taxes, keep the property insured, or maintain the property. 3-month notification of default. Notice of sale. The trustor can stop the sale up to 5 business days before the sale by curing any deficiency and paying costs. Trustee sale. A trustee sale is a public sale in which title is given in the form of a trustee's deed to the highest bidder. A real property sales contract, contract of sale, or land contract is a two-party instrument whereby the seller, vendor, retains legal title and transfers possession to the buyer, vendee. Construction loans are normally short-term loans for a term of 1 to 3 years, depending on the type of building, and customarily bear a higher rate of interest than permanent financing. Loan payments ordinarily are released based on performance of construction tasks. The final payment usually is not made until the mechanic's lien period has expired. The payments under construction loans are known as obligatory advances because the lender is obligated to make the payments. The advances made under the loan are covered in a dragnet clause that includes the future advances and prevents a subsequent lien from taking priority over the loan advances. Wraparound trust deed. When a property has an assumable below-market interest rate loan, the seller could be better off using a wraparound loan than letting a buyer assume the loan and taking back a second trust deed. Subordination agreements. When a seller agrees to subordinate seller interests, the purchaser can put a later loan on the property that has priority over the seller's lien. Taking title with a loan. When a property is sold subject to a mortgage or a trust deed, the purchaser takes title with the encumbrance but assumes no personal obligation to pay. While the purchaser must make the payments in order to keep the property, failure to do so would not subject the purchaser to any deficiency judgment. The seller is the individual personally liable on the loan. Blanket encumbrances. A blanket encumbrance is a lien, mortgage, trust deed, or real property sales contract that covers more than one property. The purpose of the Act is to provide consumers with information on settlement costs in a timely fashion. The Act applies to mortgage loans on 1 to 4 residential units, including mobile homes. The Dodd-Frank Act mandated simplification of loan disclosures. The former good faith estimate of closing costs has been combined with truth in lending disclosures. Dodd-Frank also provides for a simplified closing statement. Under the TILA-RESPA rule, the lender is required to deliver a loan estimate form within 3 days of receiving an application and no later than 7 days before consummation. The lender is also required to deliver a Department of Housing and Urban Development, HUD, loan information booklet to the borrower within 3 business days of loan application. Equal Credit Opportunity Act. The Equal Credit Opportunity Act, enforced by the Federal Trade Commission, prohibits credit discrimination because of sex, marital status, age, race, color, religion, or national origin, or because income comes from a public assistance program, or because applicant has in good faith exercised any right under the Consumer Credit Protection Act. California Housing Financial Discrimination Act of 1977. The 1977 California Housing Financial Discrimination Act of 1977, also called the Holden Act, states that a lender cannot deny a loan or change loan terms for reasons unrelated to the credit of a loan applicant. Truth in Savings Act. The Truth in Savings Act is a disclosure act requiring that term, fees, and interest yield on savings, checking, money market account, and certificates of deposit be revealed. Free checking cannot be claimed if there are any fees. The interest yield must be expressed as annual percentage yield, APY, which is based on a one-year deposit considering compounding of interest. Truth in Lending Act, Regulation Z, part of the Federal Consumer Protection Act of 1968. The Truth in Lending Act provides a uniform manner of calculating and presenting the terms of consumer loans to enable borrowers to compare the annual percentage rates and finance costs. The law makes bait and switch advertising property that is not available or that the advertiser will not sell, in an attempt to switch prospects to other property, a federal offense. Unit Quiz 1. To be a negotiable instrument, a note or draft need not be a sum certain, b. signed by the payee, c. an unconditional promise or order, d. in writing. Answer B. signed by the payee. 2. Refinancing without a discernible benefit to a borrower is a. prohibited by the Service Members Civil Relief Act of 2003, b. a violation of the Truth in Savings Act, c. considered predatory lending, d. a violation of the Mortgage Forgiveness Debt Relief Act of 2007. Answer C. considered predatory lending. 3. A maker could not use which as a defense against a holder in due course? A. A raised note. B. Prior payment of the maker to a previous holder. C. A note given for an illegal purpose. D. Legal incapacity of the maker. Answer B. Prior payment of the maker to a previous holder. 4. The usury law interest regulations did not apply to A. seller purchase money financing, b. cash loans, c. loans made or arranged by mortgage loan brokers, d. both A and C. Answer D. both A and C. 5. For loans on 1 to 4 residential units not made or arranged by a real estate broker, prepayment charges can A. be charged only for 5 years, b. not be charged on payments up to 20% of the original loan in 1 year, c. not exceed 6 months interest, d. be all these. Answer D. be all these. 6. The maximum period after a judicial foreclosure sale during which a mortgagor has the right to possession is A. 30 days, b. 90 days, c. 6 months, d. 1 year. Answer D. 1 year. 7. Which is more closely related to trust deeds than to mortgages? A. Redemption rights after sale. B. Non-judicial sale. C. Deficiency judgments. D. Legal title with borrower. Answer B. Non-judicial sale. 8. Which constitutes default by a trustor? A. Failure to pay taxes. B. Failure to make monthly payments. C. Failure to pay insurance. D. Any of these. Answer D. Any of these. 9. Which is a true statement regarding trust deeds? A. A trust deed is a two-party instrument. B. Legal title is held by the beneficiary. C. Trustor can reinstate up to 5 business days before sale. D. Foreclosure would wipe out all other encumbrances. Answer C. Trustor can reinstate up to 5 business days before sale. 10. The total required foreclosure time under a trust deed, power of sale, is most nearly A. 4 months. B. 9 months. C. 1 year. D. 18 months, and A. 4 months. 3 months plus 20 days. 11. The beneficiary of a second trust deed would be most likely to insist on a subordination clause. B. Request for notification of default. C. Subrogation clause. D. Financing statement. Answer B. Request for notification of default. 12. A junior lien holder was worried that a prior lien holder would delay foreclosure until the amount owed was so great that redemption by the junior lien holder would be difficult. To protect against this situation, the junior lien holder should record a request for notice of default. B. Request for notice of delinquency. C. Notice of non-responsibility. D. Lis pendens. Answer B. Request for notice of delinquency. 13. A financing instrument whereby the seller retains the legal title is a trust deed. B. Mortgage. C. Real property sales contract. D. Subordination agreement. Answer C. Real property sales contract. 14. Which element need not be included in a real property sales contract? A. The number of years required to pay it off. B. A legal description. C. A subordination agreement. D. The basis for tax payments when taxes are included. Answer C. A subordination agreement. 15. A dragnet clause in a trust deed covers A. Any contingency. B. Future advances. C. Additional parties. D. Increases in the interest rate. Answer B. Future advances. 16. A subordinate loan that includes the amount of other loans is known as a purchase money loan. B. Wraparound loan. C. Open-end loan. D. Usurious loan. Answer B. Wraparound loan. 17. Seller financing disclosure requires that the broker disclose A. Whether the purchaser will receive cash from the transaction. B. The date and amount of any balloon payment. C. Both of these. D. Neither of these. Answer C. Both of these. 18. A subordination clause in a trust deed is of greatest benefit to the A. Truster. B. Beneficiary. C. Trustee. D. Tenant. Answer A. Truster can use seller's equity. 19. The Service Members Civil Relief Act of 2003 protects citizen soldiers by A. Limiting credit obligations entered into before active duty to 5%. B. Allowing courts to stay foreclosure for up to 2 years after active service ends. C. Allowing service personnel to terminate residential leases if transferred. D. Prohibiting any eviction of a service member's family while the service member is on active duty. Answer C. Allowing service personnel to terminate residential leases if transferred. 20. A financing statement is removed from the records by A. Final payment of the debt. B. A reconveyance deed. C. A notice of abandonment. D. The filing of a termination statement. Answer. D. The filing of a termination statement. 21. Which is true of beneficiary statements? A. There can be a charge by the beneficiary. B. Failure to provide a statement within 21 days of request could result in a $300 penalty. C. Both of these are true. D. Neither of these is true. Answer C. Both of these are true. 22. RESPA disclosure is the responsibility of the A. Lender. B. Broker. C. Escrow holder. D. Title insurer. Answer A. Lender. 23. A lender can properly refuse to grant a loan to a borrower based on A. The high rate of loan defaults in the area. B. The borrower's public assistance income. C. The fact that the borrower is a single person. D. None of these. Answer D. None of these. 24. The Truth in Lending Act, Regulation Z, requires that the lender provide the borrower with A. The annual percentage rate. B. The finance charges. C. The taxes. D. Both A and B. Answer D. Both A and B. 25. The Truth in Lending Act, Regulation Z, provides that a borrower under a contract that places a lien on his residence has a period of rescission of A. 24 hours. B. 3 business days. C. 48 hours. D. 30 days. Answer B. 3 business days. Up to midnight of third business day,